Welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph.
Hello and welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph. Born and raised in the Bronx, Michael Joseph has spent over 20 years standing up for injured New Yorkers. I'm Kevin Rosenquist, and today we're talking about what happens when your own apartment building turns into a danger zone and what the law says about landlord negligence. Michael, good to see you again.
Thanks for having me back.
So in New York, what counts as landlord negligence?
So basically, it's the failure to use a standard of care of what a reasonable person would do or a reasonable building owner would do. More often than not, it has to do with maintaining the building in good and workmanlike condition. And if they fail to do something they should have done, for example, if they know something's broken, if they know stairs aren't in good condition, if they fail to take care of something that's broken that causes an injury, landlords can be held liable, can be sued for the negligence they caused. I mean, it's a very broad area. Of law. There's all kinds of, especially in New York City, there's all kinds of regulations on standards that buildings are supposed to adhere to that are intended to keep people safe. We have the building code, we have the health and safety, we have the administrative code, we have regulations of, that are intended to provide a safe premises for tenants in New York City. And when landlords don't adhere to these standards, or they allow things to conditions to be in a dangerous condition, they could be sued.
Mm-hmm. And we hear about things like ceiling collapses, broken stairs, and fires in older New York City buildings. Is it who's in charge of keeping that rental property safe? Is it the landlord? Is it the super? Or is there a management company? Does it depend?
All of the above, really.
Okay.
So supers usually either will work for a management company or they'll work directly for the owner. In New York, all owners are vicariously liable or they're responsible for the negligence of their supers. So the super obviously is in charge of maintaining the building. If the super doesn't maintain the building and someone gets hurt, the landlord could be sued. And if the contract if there's a contract with an outside entity to maintain the company or to maintain the building, I should say, the management company can also be held liable because sometimes they actually do employ the supers. Mm. And really, what New York law says is we have what's called non-delegable duties, right? So even if it's your building and you tell someone else to take care of it, you're still responsible because you have the ultimate responsibility to make the premises safe. You're the one who's ultimately collecting the rent. You have the responsibility to provide the safe premises. And in New York law, we also call it a habitable premises. So the landlord or the building owner is ultimately responsible, but if they've delegated their duties to third parties, such as a management company, the management company can also be sued if something within their scope of work became dangerous because they didn't take steps to maintain the property. Now, sometimes also, even though the landlord and the management company may be ultimately responsible, there's other people that can also be held liable or other companies. For example, sometimes companies are hired that negligently do work that make things even more dangerous, right? So if you have a electrician that comes in, and this is one of the main causes of fire is electrical. So if you have an electrician that comes in and doesn't follow code or doesn't properly fireproof the panel or doesn't properly inspect and upgrade his work, sometimes the third parties can be held liable. With fires, especially, one of the main causes of fires we see is supers who aren't licensed electricians trying to do electrical work. Mm-hmm. New York electrical codes are very strict on what we have to have. You have to have panels with outlets, panels with breakers, so that they don't become overcharged and overloaded. If the codes in New York are followed and the upgrades are done properly by licensed people, fires are almost non-existent, a non-occurrence. They shouldn't happen.
Mm-hmm. So it sounds like it can be quite a journey, if you will, to figure out who is at fault.
Well, you always know the owner always has responsibility. Sometimes there's a management company and sometimes there's third parties, but that's always the result of an investigation. But certainly what will happen a lot of times is we'll just sue the landlord and the landlord will come forward and then bring somebody else in and say, well, okay, I had the ultimate responsibility, but this is the guy who really messed up.
Right. Okay. So it's on them to go further with third party vendors or contractors or whatever. That's not your job. You just go right for the landlord and let them go from there.
Well, if we have information that someone else was responsible or didn't do their job properly, certainly we'll go after the third parties that failed to do what they were supposed to do. But really, the landlord is almost always the one with information. They're the ones, at least, who should know who's working on their property.
Right. Good call. Good call. So if a tenant gets hurt because of poor maintenance, what's the first thing that you would recommend they do? Should they first report it to the landlord? Should they first call someone like you, take photos? What kind of steps do you recommend?
Well, certainly the first thing anyone should do is first take photos of what caused the injury, because it's not uncommon for, once you report a condition, for a landlord to all of a sudden then wake up and fix the condition, even
Yep.
though they let it sit for months and months or maybe even years. So definitely first thing is take pictures. If you see something that's unsafe in the building before anything happens, you do want to report it, usually in writing, so they can't deny that they've received it. Nowadays, everyone uses emails or messages or some sort of chat. So you definitely want to report it in writing to the management company and the landlord. That way, if something does happen down the line, it's been reported.
Yeah, I was going to kind of ask you about how New York handles, the proof in these cases. Do tenants need to show that the landlord knew about the problem, or is just the mere existence of a dangerous condition enough?
Well, it depends on the condition. There's a few different areas or ways in which a landlord could be held liable. First, there's statutory duties, right? So if the New York has the multiple dwelling law that has a number of regulations for specific things. So, for example, if the stairs aren't within specs, if the risers are too high, if the stairs are too deep, if you don't have a handrail, those are all multiple dwelling law violations. So the landlord doesn't have to have quote unquote knowledge. The condition just has to be there.
Hmm.
Now, on the other hand, there's other types of conditions. For example, where you have to show that they either knew or should have known of a condition. Now, evidence certainly that a condition was there for a long period of time can show that they should have known of the condition. If you have stairs that are broken and another tenant's fallen, that shows it. And it wasn't fixed, that shows it. If you have certain types of conditions where, for example, one of the most common conditions is sidewalks. If you have a commercial property or an apartment building in New York under the administrative code, the landlord or building owner is responsible to maintain the sidewalk that runs in front of their properties. So how do we show that the landlord knew about this or should have known about this? Nowadays, we use Google Street Views, where you can go back in time and see what the condition of a sidewalk was months and years prior to an accident. And if it turns out that that crack, that pothole in the sidewalk was there for 4 months, 6 months, a year, you've got a good case of showing the landlord was at fault and wasn't properly maintaining the sidewalk.
Yeah, yeah, I would agree with that. I'm curious. Like I used to live in Chicago, so I've been into plenty of pretty rough apartment buildings. I mean, it's just city living, right? Um, do you feel that like do these things get reported a lot, or is it really, do people not? I guess is this a common occurrence?
Well, listen, in New York, people complain about everything. They love to complain. So that's why we have 311. Once you get 311 logs, sometimes you find gold, all kinds of things. Well, New York City actually required, if you're going to sue New York City, they actually have a law where you have to file what's called a notice of claim. And some of the New York state trial lawyers of the New York State Trial Lawyers Association actually maintains a log of them. So we can actually go back 5, 7 years and look at all the location of dangerous sidewalks in the city of New York. So people definitely complain. There are 311 logs. These tend to be some cases that have been brought against the city, but still they do document cases where there are defects within the city of New York, in front of apartment buildings, in front of stores. And certainly people complain. They usually complain to their supers, and it's not uncommon for a tenant to have an accident and say, yeah, I texted the super a picture of this 2 months ago, or they find a neighbor who complained about it and who texted the super or told the super. And really, even if someone says, yeah, I reported it, I told it to them, that's enough. And it really becomes a question of, are they being truthful or not?
Mhm. Yeah, that's always a part of it as well. What about insurance? How does the landlord's insurance play into this? Do insurance adjusters get involved? Is that who the tenant will ultimately start dealing with at some point?
This gets a little complicated because New York doesn't have a direct action statute against insurance companies like some of the states do. In New York, the way it works is you would typically either bring a claim against the landlord or you would file a lawsuit against the landlord. But ultimately, the insurance company is the one that's going to be responsible. So it's not at all uncommon for us to negotiate with adjusters. Usually, the insurance company will step in and hire the defense lawyers. And really, the ultimate decision on whether to settle and whether to make an offer and who and how much to pay is very often with the insurance company, even though in name they're not actually sued.
Okay, that makes sense. I want to talk about the fire because obviously that's a pretty big one. If that breaks out, someone might get injured. How do you prove the landlord or management company failed to maintain proper safety standards, especially if it's a pretty substantial fire?
In fire cases, more often than not, you have to work backwards. And to be clear, there's two types of liability in fire cases, right? There's the cause of the fire, and then there's the safety features that should have been in place in case there was a fire.
Mm-hmm.
All right. So let's talk about cause first. In any major fire, the fire department is going to do what's called a cause and origin investigation, and these are experienced, highly trained fire marshals who can go into a scene. They can see patterns. They can see where a fire started based on the amount of damage that's done, based on the char, based on markings on the walls that reflect flames. These guys are very, very technically skilled, and they can find where a fire started. So then the next step is, okay, it started here. What was the cause? We know what the origin is. What's the cause? If we see a charred electrical box, we know it was an electrical fire. So that's really one of the main causes. Most causes are electrical in nature. For example, you have a panel that isn't up to snuff. You have a panel that doesn't have the proper fireproof framing around it. If you have it on wood can catch fire. If you have it on plastic, it's supposed to be metal because metal has the highest flash point, right? If you see it on a fire pattern around a stove, it may have been a gas fire. Maybe there was some sort of accelerant or something that came in contact with a fume, right? We've had plenty of cases where there's work going on in a building and they failed to shut off the main line of the gas so that work, if you're can be done around the kitchen area where the pilot light is, because it always emits some gas, right? So if you're working around with something that say has flammable vapors, you want to make sure any heat source is off before you start doing the work. That's one of the other big kind of cases we see. Now, sometimes the landlord may not necessarily have been at fault for the cause of the fire, right? A tenant, neighbor falls asleep smoking a cigarette in bed, right? That happens. Or arson, right? But remember, the fire itself may not necessarily have been what caused the injury. Maybe it was smoke inhalation. Right? So if you have a case with smoke inhalation and a fire started, did the fire alarms go off? Were there fire alarms? Were the fire alarms functioning? Did the fire alarms give the tenants the chance to get out? New York has very stringent laws on every apartment has to have working carbon monoxide detectors and smoke detectors. You also have to have self-closing doors so that the fires and smoke doesn't spread and is contained, giving people a chance to get out. So sometimes it's secondary things or secondary defects or secondary code violations that actually cause the injury. I mean, we've had cases, for example, where a fire breaks out in a building and people can't get down the fire escape because the fire escape is in a workable condition. So they end up jumping and fracturing something to get away from the flames. If the fire escapes were in good condition and they're supposed to go down, be able to be dropped so people can climb down to safety. If they have to jump because the fire escape can't be lowered and is not in good condition, then that's a secondary kind of liability.
Mm-hmm. Wow, yeah, there's a lot there that you'd have to look at for those. Wow, I mean, which makes sense, obviously. Like, there's a lot going on with something like that. I know.
Before we move on, you mentioned, for example, stairs before, right? Now, if all of a sudden you have a condition where someone falls down the stairs because there's no handrail, but there's smoke, the fire may have precipitated the incident, but now you have a secondary dangerous condition that also played a role in causing the accident. Yeah. If the stairs are bad, if they're too deep, if they're not uniform, right? Because the code requires them to be uniform, so that you have proper step geometry. So as you're walking down the step, you can kind of judge by motion where the next one is. If you step down and all of a sudden the step's not there because the step is too deep, then you have a dangerous condition superimposed while there's smoke and you can't see necessarily where you're stepping.
What are some of the biggest mistakes you see people make, after they might have been hurt in their own building? And what's the smartest, what's the smartest steps, the best process someone can follow to protect their rights?
Well, some of the biggest mistakes we see are people who just get hurt and then do nothing, right? And then all of a sudden, 2 or 3 months later, they can't live with the pain anymore. They can't live with anything, with the problems they're having. They can't function like they used to. Now they want to sue. But the problem is they didn't document what happened. They didn't document the conditions that caused the injury. And then maybe they didn't even document the injury. Maybe they didn't even go to a doctor within 2 or 3 months. So that makes it even harder to say, what we have to be able to prove in the law is that, one, there's a dangerous condition. 2, there's a causation. If the condition caused the injury, and I think New Yorkers are skeptical by nature. So if you say you were so badly hurt from this incident, but you didn't go to the doctor for 2 months, everyone's going to be like, huh? No.
Yeah. Yeah. It's bad luck. That's bad luck. Yeah.
Yeah. So I think you have to line up things to be able to seek the damages you're entitled to. You have to take pictures. We have to try and get statements, maybe to see if other neighbors had similar problems or if they reported it. We want to find we talk about things like ceiling collapses. Most ceiling collapses are caused by some kind of leak above. So we want to figure out if there's been plumbing work, if other tenants have complained about leaks, about mold, for example, because that could be indicative of a wet condition that's not being addressed. Has there been any pipe work done in the building? Those are all the contributing factors usually to a ceiling collapse.
Mm-hmm.
And the next thing I think people really want to do is, if you are hurt, you want to get medical attention and be properly diagnosed, because sitting at home and saying, ow, it hurts, doesn't prove a case. You really need a doctor to objectively verify what's wrong. I would never tell someone, go to the doctor for the sake of your case. But on the other hand, if you don't go to the doctor, you have a very strong chance of losing your case.
Right.
Why? Because you want to sit home and be stoic.
Mm-hmm. Stoic. That's one way to put it, huh?
Well, yeah. I mean, if you're not properly diagnosed and all you have is your word these days, people just don't believe you, even if you're telling the truth.
Right.
So in litigation, it's not always about what happened. It's more about what can you prove and what evidence do you have to show.
Yep. Yeah. Good call. All right. Well, good stuff, Michael. That's it for today's episode of Trial Talk, insights from experienced New York trial attorney Michael Joseph. If you've been injured because your landlord ignored dangerous conditions, visit newyorktriallawyers.org to connect with Michael and learn more about your rights. Thanks for listening. Don't forget to subscribe and leave us a review so more New Yorkers can find the guidance that they need. Michael, always great chatting with you. Thanks so much for your time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.